Cause. Ms. Parrish, you may proceed.
Yes, we recently went to court to the defendant asked that post-majority support be ended for our oldest son. It was written into our divorce decree, and so it was you had ordered for a friend of the court to do a review. So they ended up ending that. And without that funds, now I would like to have a review of spousal support that was ordered that Mr. Parrish hasn't paying, that is ordered in our divorce decree and through the spousal support for $700 per year, and that has not been occurring. Also, it's ordered that in the previous order, medical, he pays 60% and I pay 40 of the uncovered uninsured, and there has been two larger bills. I've been paying the smaller ones, just doing it myself.
This hearing isn't about changing the divorce agreement, it's about enforcing it. The judge makes that clear almost immediately. If the original court order says support payments and medical expenses must be paid, then financial hardship alone doesn't automatically erase those obligations. The court's job is to determine whether those orders have actually been followed.
Just doing it myself to avoid conflict, but two of the larger ones, I would like to have him pay his portion. And then the third thing is tax filing status. I have the children, well, now I guess the oldest has aged out, but our youngest, I have about 300 nights, and I would like to have filing status.
What does the judgment provide as it relates to the tax deduction?
It says that we are going to rotate once the oldest ages out, but that was supposed to be with the post majority. So now that's why I'm asking for that to change so that I can file her.
Okay, well, let me tell you, the court does enforce the judgments and the orders of the court. So in this matter, if the judgment provides that the parties would alternate filing status, the court is not going to change that. The other issues, so I asked Mr. Parrish, she stated you're not paying the spousal support or contributing to the medical. What's your response?
I have not missed any of the child support payments, of course.
She didn't say child support, she said medical.
Oh, no. Any medical bills, both of the children, both Alan and Alina, are covered on my medical. I think, I'm not sure what Kelly has in regards to any additional insurance, but I have always covered them. So whatever medical.
Okay, she's not talking insurance, she's talking uninsured. So it's whatever your medical is paid that they have not covered. She's saying there's an additional deficiency there that you have not contributed to. Ms. Parrish, have you provided him with I guess, an accounting of what insurance paid and what's not been paid?
I have multiple times. I do have those dates that I have sent him photos of the actual bill with the account number so he can call to Bronson. And they're both through Bronson Battle Creek. They're local providers that are in. I always go to in-network, so it's less expensive.
Okay. Well, are you saying you didn't get those, sir? Or
No. I'm not saying that. I have received, and the bills that still need to be paid off in regards to both of the children, whatever I can pay, I try to pay. I am in extreme financial distress at this point in time. I'm not shirking my responsibilities for Alan or Alina whatsoever, and it's not meant to seem that way. I don't think that Ms. Parrish understands the
okay. Well, let me tell you what
that
happens.
I'm currently in.
Well, I'll tell you what happens. The court enforces its judgments and its orders. And
yes,
all of that is well and good. And we understand it may not be that you're intentionally shirking your responsibility, but the issue is whether you are complying with the orders of the court. And she's saying that you're not. And what we're going to have to do is, there's a dispute as to that, then we're going to have a hearing and make a determination of whether, how much is owed, et cetera. in this matter, and then you'll be required to pay that particular amount.
Okay, I'm not disputing that I do owe. I will be more than
At
willing.
this point, the hearing takes a practical turn. Instead of arguing over who is right, the judge focuses on the actual numbers owed. Since Mr. Parrish doesn't dispute the unpaid amounts, the court lays out exactly what must be paid and explains the legal options available if those payments still aren't made. It's a reminder that court orders remain enforceable until they're officially changed.
More than willing to
Okay, on the medical.
have Kelly tell me exactly what it is I owe, and I will do my best to make payments on what I owe.
Ms. Parrish, what is the amount? Do you know what the amount is on the medical that's owed?
I do. I did make a $140 payment a year ago towards that. And so his balance towards the total, I owe 214 and he owed 320. He did pay $40. So right now he currently owes 280 on app. For Alina, I just got that bill and provided him with that probably 2 weeks ago, and that's $169. And I don't know the math on that. 60%, $169 would be his.
And the amount of the spousal support that he's delinquent on, how much is owed on that?
Only for 2023, there's still 1 year left of spousal, but for 2023, he owes $496.
Okay. Are you disputing that amount, sir?
Oh, no.
What I'll do, Ms. Parrish, I'll allow you to put in place an order which states that he is in fact delinquent and owes spousal support in the amount of $496 for the year 2023, and that he owes the particular medical, the 280 and whatever the percentages is of the other amount. Let me see.
Okay.
His amount would be of the 169 would be 101.40, so $101.40.
Okay, thank you.
Put that amount in, and then at that particular point, he has those numbers that he ends up having to pay. If he doesn't pay, then you can proceed. At that point, ma'am, you can do a number of things. You can go after and seek a garnishment of his wages. You can seek an attachment of assets or any other, seizure of assets, et cetera, which would satisfy that obligation. That's up to you. So the court will let you put in place that order, and you can submit it under what they call a 7-day notice of entry. So if you get it in within 7 days of today's date, you don't need to schedule it up for entry. If you don't get it in within 7 days of today's date, then you'll have to send it to him, get it up noticed of entry, and then we'll have to have a hearing on that.
Okay, do I just type it and mail it directly to him?
You have to mail it to him. You do the original to the court with a notice of entry.
Okay. Again, Your Honor, I want to go on the record as saying I let a lot of this go because of the post majority, but when he entered to have that terminated, I
don't need to know that. That's irrelevant to today's hearing. So I understand, but just get the order entered, and then we'll have the numbers and the amounts that are owed. Okay.
Thank you very much, Your Honor.
Okay. Thank you.
At this point, the hearing takes a practical turn. Instead of arguing over who is right, the judge focuses on the actual numbers owed. Since Mr. Parrish doesn't dispute the unpaid amounts, the court lays out exactly what must be paid and explains the legal options available if those payments still aren't made. It's a reminder that court orders remain enforceable until they're officially changed.